Honorable Senators, we are meeting to continue our study of Bill C-48, an act to amend the Criminal Code dealing with bail reform. Appearing on our first panel, we're pleased to welcome from the Canadian Bar Association, Melanie Webb, Counsel and Secretary, Criminal Justice. From the Canadian Civil Liberties Association, Shakir Rahim, Director of the Criminal Justice Program.
Good afternoon. By way of introduction, I am a lawyer and Director of the Criminal Justice Program at the Canadian Civil Liberties Association. I will speak today about the reality of the bail system in Canada and the CCLA's two recommended amendments to Bill C-48. In 1976, Parliament introduced the first reverse onus on bail. Gary Trotter, author of the leading text, The Law of Bail in Canada, and now a Justice of the Court of Appeal for Ontario, wrote the following about the debate in Parliament. Quote, "In the House of Commons and during the proceedings of the Standing Committee on Justice and Legal Affairs, there were calls for an empirical foundation to justify the proposed changes. As the Department of Justice had foregone an earlier opportunity to have the functioning of the Bail Reform Act evaluated, the government was forced to rely on anecdote and speculation." End quote. 46 years later, and the government still has not gathered any evidence that reverse onuses enhance public safety. But what do we know? We know that bail is being denied at record levels. In 1981, 21% of those held in provincial and territorial prisons were in pretrial detention. In 2001, 41%. Last year, 71%. We know that judges have described conditions in provincial and territorial prisons, and these are their words, as dire, appalling, overcrowded, harsh, and notorious. Any human being would want to get out of a place like that as soon as possible, especially if they face a lengthy delay before trial. The innocent are under tremendous pressure to plead guilty. This threatens the presumption of innocence. As a unanimous Supreme Court of Canada wrote in the first paragraph of their 2017 decision in R.V. Antic, the right not to be denied reasonable bail without just cause entrenches the effect of the presumption of innocence at the pretrial stage of the criminal process. For these reasons, the CCLA does not support the introduction of any reverse onus provisions. However, there are two amendments we recommend to address the most significant shortcomings in Bill C-48. First, the CCLA recommends that a justice be required to make a statement in the record of proceedings of how they considered Section 493.2 of the Criminal Code. This section of the Code requires a justice to consider the particular circumstances of Indigenous and other overrepresented groups who are disadvantaged in obtaining bail. However, Section 493.2 is not often considered by justices, despite it being a requirement to do so. This amendment would ensure justices proactively and meaningfully give effect to what is already the law. It is also fully in line with the preamble of Bill C-48, which states certain groups are disadvantaged in obtaining bail and overrepresented in the criminal justice system. The CCLA also supports any amendment that would state that Black persons are overrepresented and disadvantaged in obtaining release as part of these provisions. Second, we recommend an amendment that would remove the IPV discharge reverse onus. You have heard from many groups on this point, and the CCLA endorses their testimony. If there was ever a bill that required sober second thought, it is one that pressures the innocent to plead guilty, exacerbates the overrepresentation of Indigenous Black, and other vulnerable groups in the criminal justice system, and does so even though we do not know whether it will accomplish any of its purported benefits. That concludes my opening statement. Thank you.
Thank you, Mr. Rahim.